Hi, I'm Dan Covington. I'm an estate planning attorney. I help people leave the legacy they intend. Today we're going to talk about the fundamental question. Will or a living trust? Which is better for me? First we'll talk about a will. This is something most are familiar with, at least as a story from someone else, if nothing else. In a will, as you know, a provision is going to say, when I die, I leave this to this person, everything to my spouse. If my spouse doesn't survive me, divided among my children, something to that effect. The assets in your will that I own in my sole individual name when I pass away, those are subject to being probated per the terms of my will, right? That's no surprise. So the will is going to, in effect, through the probate process, the executor is going to gather up those assets and essentially distribute them with court supervision. Your will, I may in my will name my spouse, for instance, as the executor to administer my estate, right? So the executor then shows up with the will. They hire an attorney for probate. Probate, as you may or may not know, is a court-supervised administration. Likely takes several months, sometimes 4 months, just for the creditor waiting period to pass in Kansas. The basic process, it can change quite a lot, but the basic probate process in Kansas, the court's originally going to accept the will for probate. The court will formally appoint the executor, issue something called letters of administration, which are kind of the executor's formal walking papers, so they can show, yes, I have authority to act on behalf of this estate. The executor is going to file an inventory of the estate. Usually that's due in Kansas within 30 days of the will being accepted. I'm sorry, 30 days of the executor being appointed. Executor then is going to, again, this is the general process. The executor is going to give notice by publication and directly to heirs and creditors. Then there's going to be this waiting period, as I said, to give opportunity for creditors to file claims against the estate. This is one of the troubles with people find with the probate process is it's the name of the game is due process, right? It's give everyone notice, give everyone opportunities to object to the will, to object to the distribution, to file claims against the estate. So that can be time-consuming, expensive, cumbersome, lots of things people don't like about it. Then there's, as I said, once you've given notice to creditors, there's this waiting period to give them time to file claims against the estate. The court is going to supervise more or less, depending on what kind of probate procedure is selected based on the complexity of the estate and what kind of issues you have. Then the executor is going to account for ultimately and distribute the assets with the court approval, and the estate's going to be closed. While I can rattle that off from a few bullet points in a minute or so, you are talking, like I said, 4 months for the creditor waiting period if there are unknown creditors, right? So typically 6 months may be a short probate procedure. On the other hand, if you use a living trust for your estate plan, you know, I push these because there are just so many good things about a trust. So in this, I'm going to say when I die, perhaps if I'm married, my spouse is going to have continuing control and use of all of our assets during their life. Then after the spouse passes away, maybe a typical example is those assets can be applied then for care of our children, maybe so long as they're minors. Maybe an aunt or an uncle will be a trustee for the children's assets to take care of them as long as they're younger. Then perhaps the assets are going to be available for post-secondary education for the kids, with maybe the remainder of the assets going to them, each getting their share at age 22, or some people like to sprinkle those out, as we say, at maybe a portion at age 22, some at age 25, some at age 30. So lots of different ways those can be distributed. But when I sign a living trust, I'm also going to title my major assets into my trust, because unlike a will, a trust doesn't kind of gather up assets that are just owned in your individual name. But you do typically do what's called a pour of a will, which is a backup to say if I forgot to put anything into my trust, the court could probate it into my trust because my trust is my genuine estate plan. For administration of a trust, there's kind of minimal notice to beneficiaries and some accounting per state statute. This is just kind of a check to keep a trustee honest, right? The beneficiaries get notice that the settlor of the trust, the person who started the trust, has passed away. The trust is now irrevocable. It can't be revoked. And you're going to, at this time or sometime down the road, be entitled to a benefit. And here's kind of what's in the trust at this point. Essentially, the trustee is, they manage and distribute the assets of the trust. So the court doesn't need to supervise that. The proceedings, there aren't really formal proceedings, and if there are, those aren't filed or public. And the trust provisions control how the trustee may act. Trustee has a little bit of discretion, but generally they're told how to manage and administer the assets and to whom and when those get distributed. And ultimately the trustee owes a duty to the beneficiaries. So as I said, there are kind of checks and balances on the trustee's behavior, and they do ultimately answer to the beneficiary, although the beneficiary doesn't call the shots. The trust is going to say what the beneficiary shall and shall not or may do. This is a general take on a will versus a trust. There are some complexities to both, and there's obviously a need for specific advice if you have this question, but I hope this helps you out with the general picture. I'm Dan Covington. You can always find me at Estate Plan Kansas.